Good morning, Mr. Ross. Good morning.
Good morning, Madam Chief Justice. May it please the Court.
Thank you.
My name is Mitchell Ross. I'm here representing Joseph Perroncello, the appellee. We are seeking affirmance of the Superior Court judgment ending this litigation after conveyance of the property at issue from the owner, the seller, Mr. Donahue, to Mr. Perroncello at the full purchase price and payment by Mr. Perroncello of carrying cost damages. And if I may, I would like to focus my argument on the question of whether, after specific performance was effectively ordered and delay damages paid, the defendant in this case, Mr. Donahue, has the right to obtain...
Well, may I interrupt you? Was specific performance ordered by the trial judge?
Yes, Your Honor. What the trial judge said was, in response to Mr. Donahue's motion to dismiss and offer of judgment for specific performance, in the vernacular she said, put up or shut up. Buy the property, she says to Mr. Perroncello. Sell the property, she says to Mr. Donahue. And here is the key phrase, Your Honor. In accordance with the terms of the purchase and sale agreement dated April 3rd, 1998. Mr. Donahue could have not moved for specific performance in that way, and Mr. Perroncello certainly could have fought it and not complied. But that's not what happened.
I take it was the seller who initiated the attempt to get specific performance, correct?
Exactly. What was happening here, Your Honor, is simple to see from the record. This case was brought at the end of June of 1998 after the seller and the buyer had a falling out over whether an oral extension of the time to close had been granted. The buyer, Mr. Perroncello, went to court and obtained a lis pendens, a temporary restraining order, and then a preliminary injunction forbidding the sale. At that point, Mr. Donahue embarked on a campaign to try to lift the lis pendens, lift the preliminary injunction, and be free to sell to someone else, and was denied by the court below.
But explain to me that the TRO, or maybe the preliminary injunction, entered on June 30th, is that right?
I forget.
I got the right date?
The TRO entered June 30th. That's correct.
All right. So what happened in July and August? How come the sale didn't close? Was your client prepared to close during July and August?
Well, there's an argument about that. My client maintains that he was in the process of and quickly obtained financing from Citizens Bank that had prevented him from closing on the original closing date of June 5th.
Yes, but that happened in June 25th or something like that, right?
That's correct, Your Honor.
So what happened in July and August is what I'm trying to...
Apparently, they were fighting over the terms on which the closing would take place. I cannot tell you whether one side was asking for more money than the purchase price or the other side was asking for less, but they were clearly at odds. And
because the judge clearly suggests that she was of the view that now this had become a game, where your client was simply had Mr. Donahue over a barrel, had a lis pendens, and was simply not closing so as to leverage a lower price. And that's when she said, that's it. It's put up or shut up time, as you suggest.
I agree.
Am I correct, excuse me, Mr. Ross, that your client offered more money?
No, Your Honor. Actually, at one point he did.
What is the 229? What was the price? 1.2?
The total price was $2,250,000.
And wasn't there an offer at some point for $2,290,000 or $300,000?
I think $2,300,000. But at that point, as happens in hard-fought litigation, particularly during this stage, I think the party's position is hardened. And Mr. Donahue at that stage just did not want to sell the property to Mr.
How does the
Perroncello.
election of remedies play into this case?
Our position, Justice Cowan, is that by going to the Superior Court and asking for this remedy, that is the remedy of specific performance, and then my client having changed his position and bought the property, to his benefit or disadvantage, but it's clearly a change of position, that Mr. Donahue should be held to have elected a remedy and not be entitled to any further remedy because he now has full performance under the contract. That is, under our election of remedies doctrine, a choice that he made knowingly. He could have fought it.
Do you take the position that you can never have liquidated damages when specific performance is also present in a case?
Correct, Your Honor. I believe that the remedy of specific performance is wholly inconsistent with damages for total breach. There are damages for carrying costs, as were awarded here, consequential damages, but it is wholly inconsistent to order specific performance in accordance with the terms of a contract. Put the party...
The delay damages were just from the May to June.
Correct.
I mean, nothing was done with regard to delay damages?
Mr. Donahue, according to the record, never asked for delay damages and never appealed the judgment of the Superior Court awarding him the $13,000 through June 5th. That's correct.
What effect do you think Judge Ball's statement was that she was, however she phrased it, she's reserving to everybody the right to seek, she said, meanwhile the remaining counts and counterclaims here shall survive, specifically allowing the parties to pursue money damages against each other?
Both her original order, Justice Cowen, and her amended order make it clear. She was preserving parties' rights, not creating new rights. What she did not want, which apparently was being argued in the court below, is that her order was the end of the case. She wanted to leave it open for Mr. Donahue to claim that he was entitled to additional damages because there had been no hearing on the merits.
But how do we know that she wasn't leaving it open for him to claim liquidated damages?
Well, whether she was or she wasn't, the question is whether he is entitled to liquidated damages. I don't think the issue...
Stated differently, I suppose, she's saying, and nobody has briefed her on whether Massachusetts law you can get both specific performance and liquidated damages. She's simply saying, I'm not deciding the issue. You can claim it, you can pursue it, and that's fine.
That's exactly right. That is the way we read her order, and I think that is confirmed by the fact that over a year later, in 1999, she confirmed that order, making it an order instead of a judgment for, I think now, obvious reasons. She didn't want it to foreclose this argument, but reiterated exactly the same language. That is, that the parties, not just Mr. Donahue, were free to sue each other for money damages.
Wasn't the effect of that order the one preserving monetary claims for later pursuit? Didn't that also have the effect to sort of bar the merger doctrine and also raise judicata as a defense that your client might raise?
I think that's fair. I don't believe that we have ever relied on merger or res judicata. We are relying instead on the very basic principles of damage law, that one cannot get more damages than were within the expectation of the parties, and that the whole purpose of damages law is to put the party in the same position as if the contract had been performed, or to put it in the negative, it is not the policy of our law to award damages which would put a plaintiff in a better position than if the defendant had carried out the contract. That is the basis of our position.
What about cases in other states on election of remedies? Do they tell us anything? Do you know?
I don't think, at least in my review, Justice Cowen, there is any state that says that once a remedy is elected and two conditions are met, that it is an election which essentially bars the party from going forward with other remedies. And the two conditions are, first, that the remedies are inconsistent, and I submit that specific performance is inconsistent with total breach damages, and secondly, that the party changes his position in reliance on that election of remedy. And here, Mr. Perroncello bought the property at the full price.
I take it, stated differently, that if your client had gone to Judge Ball and saying, please order specific performance, she would have said no. She would have had to determine whether there was a breach. If Mr. Donahue had opposed specific performance, she would have said, she would have had to have decided if there was a breach, and she would have said, Donahue, is entitled to elect liquidated damages or specific performance, and he hasn't elected specific performance.
Precisely, Your Honor. In an ideal world, what would have happened here is the judge in the trial court would have the time and the resources to say, okay, there is a disputed issue of fact, come in here for a hearing on the merits in a week, a month, whatever time is necessary to dispose of this relatively simple issue of credibility, and have decided the case on the spot. But Mr. Donahue didn't push for that, for perhaps very practical reasons, and instead, after exhausting his ability to try to get some temporary relief, said, show me the money. I don't believe that Mr. Perroncello can close. Judge, order him to close at the full purchase price, and to the surprise of no one on Mr. Perroncello's team, Mr. Perroncello did that.
Mr. Ross, I have not looked at the briefs in the appeals court. Did you argue in the appeals court that Massachusetts law is an election of remedies?
I believe I did, Your Honor. The basis of our position, since I became involved upon the appeal of this case to the appeals court, is that having gone forward with essentially compelling summary judgment, I beg your pardon, specific performance, that Mr. Donahue is simply not entitled to additional damages, and it really makes no difference whether they are liquidated or actual. The damages, whether liquidated or actual, serve the same purpose to substitute for a failed transaction. He cannot get it twice. He cannot get it twice.
And I know I may be testing your memory because that case, I think, was argued, February 2005. Did you address the Kelly case on which the appeals court
Yes,
relied?
Your Honor, because it was raised, and our position on the Kelly case is that it is simply inapplicable to this situation. It doesn't matter whether one takes a first and only look at the question of whether liquidated damages are appropriate, or whether someone takes a second look at whether liquidated damages are appropriate. Liquidated damages are only appropriate if there is a breach not cured. That is why I don't think the question of whether the record compels a finding that Mr. Perroncello did or did not achieve an oral agreement to extend the closing date is critical to the decision of this court, because whether or not he did, he subsequently, on September 23rd, fully performed the contract. And
Well, in Kelly, there was a third party who bought the
Exactly.
property for more money, and
Right.
here it's the same two parties.
Yes, Kelly, I need not tell this court, makes perfect sense viewed in light of the expectation of the parties who enter into these sorts of very common contracts. It is their expectation that if the buyer does not buy, then the seller will keep the deposit and the parties make a clean break. That is the essence, to me at least, of Kelly. That's obviously not what happened here. We don't get to that issue because there was full performance and, I should add, payment of the carrying cost damages. And that was addressed, I believe, Madam Chief Justice and Justice Cowan, at the appeals court level.
In your brief, at least maybe this is the way I read it, you indicated that your client objected to the entry of specific performance, which was the remedy he sought. Is that correct, or did he just object to the date set for the closing?
It was the date,
Okay.
Justice Court. It was the date. He was perhaps seeking better terms for his mortgage financing. He wanted additional time. The point, however, is that when he was put to the test, he came through. He bought the property as ordered. I should also raise the fact that there is another basic principle of damages law implicated in this case, general contract law, that contracts are enforced and interpreted to fulfill the expectations of the parties. And I would ask the Court to review the precise language of the contract here. We're here talking about a buyer's default clause. That is, what happens if the buyer's default. And the language, the plain meaning, and the plain wording of that clause is clear, that in the event the buyer fails to fulfill the buyer's agreements under the purchase and sale agreement, and in that event, the deposit is retained by the seller as the seller's sole remedy at law or in equity. Here, back on September 23rd,
And your time is up, Mr.
that
Ross.
deposit was kept. Thank you, Your Honor.
Thank you. Mr. Farrar?
Madam Chief Justice, honorable members of the Court, my name is Albert Farrar, and in this action I represent Paul Donahue as trustee, and we're seeking affirmance of the decision of the Appeals Court overruling the grant of summary judgment by the trial court. And I want to start by pointing out what I think are a few misunderstandings, perhaps, that this Court has about what happened in the trial court below. Let me start with what Justice Cordy asked a little while ago, and that was whether or not Mr. Perroncello objected to the order of the court ordering the sale of this property. And he not only objected, he also filed, this is in the record, a notice of appeal of that sale. And I think it's more than slightly ironic that at this stage, Mr. Perroncello is now relying on the very order that he appealed, and the notice of appeal is in the appendix. And
But he didn't perfect that appeal, right? I mean, that appeal is not in front of us.
in truth, it was a nullity at the time it was filed, because obviously all of the claims of all the parties hadn't been decided at that time, Chief Justice Marshall. Secondly, but he did appeal that decision. He thought it was effective. And this was after the sale had already closed. Secondly, Judge Ball, when she learned that in denying summary judgment, Judge Giles had in a footnote said that perhaps Judge Ball's order for the sale might preclude Donahue from pursuing his money damages, Judge Ball, over a year later, in September of 1999, made it quite plain that she was preserving Donahue's rights to seek damages for breach here. And she
that is clear. I don't think there's any doubt about that. But had she actually gone further and said, and I hereby award damages, in other words, she's preserving the claim, there's no question, but had she gone further and actually not just said you can pursue your money damages, but I'm awarding liquidated damages of $150,000, and that order had been appealed, we would be in the same posture. So it's not that she did something improper, it's what is the legal effect of her judgment.
Well, what she did was she did two things. First of all, she changed it from a judgment to an order, and she also removed, and this is in the record at 227, she also removed the specific performance language from her earlier order, calling it now an order for conveyance of 198 Beacon Street. And that action was completely consistent with what the record before her when she made her decision back in September of 1998. This was a case where Donahue had done everything that he was supposed to do, and where Donahue's expectation in the event of Perroncello's breach, and there can be no doubt that there was a breach by Perroncello on June 5th, 1998, Donahue's expectation was not that he was going to get into a lawsuit where the then existing list pendant statute was a debilitating drain on him financially. His expectation was that he would continue to own the building in the event of a breach, and that he would retain the liquidated damages of $150,000.
But having asked for specific performance and having received an order for specific performance, how does your client now explain the fact that he was entitled to liquidated damages? Aren't they inconsistent remedies?
I think the use of the language specific performance was unfortunate. I won't deny that, but I don't think it should be in any way dispositive of this case.
She enters an order, she doesn't even use the term specific. I'm talking about Judge Ball. She doesn't even use the term specific. She just says, she says on Mr. Donahue's motion, I'm entering an order for conveyance of the property.
That's the subsequent order, Chief
Yeah.
Justice Marshall. That's the one, when called to her attention that there may be a perversion of what she was intending to do, clearly intending to do, back in September of 1998. Don't forget, the day that she issued this order, September 4th, 1998, the day after, Donahue's mortgage was due on the property.
Yes, but again, she said, I'm treating it as Mr. Donahue's motion for an assent to the enter of judgment, conveyance at issue shall occur on or before. It was your client who went into court and said, order that the property be conveyed, correct?
With the full understanding that the court was going to preserve his rights to seek money damages.
Of course you can preserve the rights, but he may not get the rights.
But to punish him for
No, you're not punishing him. You're not punishing him. Liquidated damages say if a party breaches, I'm going to have to go out, I'm going to have to market, I'm going to have to go to all the hassle. Who knows what has happened to the market conditions? They may have declined, and in order to protect me, the seller, from having to negotiate with a third party, we all agree that if the buyer breaches, we get $150,000 damages. I don't have to prove all those damages. But if I sell to you, I may be entitled to delay costs, I may be entitled to attorney's fees. I don't know whether they were provided under the contract. I may be entitled to whatever mortgages, I've had to borrow money, but I'm not entitled to liquidated damages.
But by that time, Perroncello had breached the agreement. Perroncello's rights under the agreement had expired by then. It expired on June 4th or 5th.
He did, but you won the case. You got everything you were entitled to under the contract. You won. You got specific performance.
Absolutely not. What we were entitled to under the contract was to retain the building as of June 4th, 1998, and retain the deposit.
Well, that was an alternative remedy.
That was the only remedy we've ever sought in this case. The only remedy we sought were damages.
You didn't ask for specific performance?
The request for specific performance was made not as part of the counterclaim in this action, but
you went into court, didn't you? You went into court and asked you asked the court to order a sale.
Judge, the run-up to September 4th, 1998, as I understand it, I was not there, is that from the beginning, Perroncello, after suing on June 30th, 1998, continuously represented to the particular Superior Court justice who superintended this case for 2 months and saw the parties on 6 different occasions during those 2 months that he was ready, willing, and able to perform. Donahue said to the court, I heard this before, I don't believe it, dissolve the lis pendens, let me go on with my ownership of this property, which was vacant and costing quite a bit of money to maintain, and let me seek my liquidated damages, which is what he counterclaimed for. Perroncello continuously represented, as I understand it, to the trial court that he was ready, willing, and able to perform, something he'd been telling Donahue, yet he did not. On July 9th, 1998, Donahue sought dissolution of the lis pendens. Perroncello came in and said, I can close in 10 days. I can close in 10 days. And the judge said, I'm not going to dissolve the lis pendens because Perroncello has represented he could do it. You've read the colloquy between Perroncello's lawyer and Judge Ball in the record. By September 4th, 1998, Judge Ball was convinced that what Perroncello was doing was using the lis pendens to try to extract financial concessions from my client, who was in dire straits. She wanted to do equity. That's what she told everybody, and that's in the record.
Did your client say, I do not want to sell the property to him? No, Judge, I do not want to sell the property to him.
No, my client said, I will sell the property to him as long as I am sure that I can seek the liquidated damages which I bargained for when I made the contract with this fellow. And those were the circumstances under which the property was sold, as I understand.
So are you suggesting that Judge Ball's order preserving rights to money damages, in essence, sort of took out this election of remedies problem? In other words, said, by this by entering this order, I'm not suggesting you've elected one remedy to the exclusion of others, but I leave that other remedy open?
Yeah, and the appeals court saw it that way too, citing to the Apparel Art International case, which admittedly is a First Circuit case.
But why isn't that wrong? Why isn't that just a plain incorrect view of the law? You can't have specific performance plus liquidated damages.
The trick here is that you can have what happened in this case once there has been a breach by the buyer. I absolutely agree with you, Justice Spina, that you can't have specific performance and liquidated damages when there is no breach.
No,
but
wait a
but
minute.
here there was a breach.
Well,
No,
you say there
you
was
don't get a remedy unless there's been a breach.
I'm sorry.
You don't get a remedy, and you don't get liquidated damages unless there's been a breach.
I absolutely
And you don't
agree.
get an order for specific performance unless there's been a breach. And the seller elects that as a remedy. There has to have been a breach. You can't go into court before there's been a breach and ask for an order. In other words, your client could not have gone in on, let's say, May the 31st and said, I'm worried. Order him to close on June, whatever the closing day was, June the 5th?
June 5th.
Yeah, you couldn't have got that order.
And I'm not
Okay.
suggesting we could have. But what I'm responding to is the argument, maybe implicit argument, that somehow we were made whole in this case. We got full performance of this purchase and sale agreement, and now we're seeking the penalty of liquidated damages.
Well, if you received an order for specific performance and Judge Ball also proceeded with the trial and you were awarded liquidated damages, the shoe would be on the other foot, and the appeal would be that you cannot have specific performance and liquidated damages. So we would be faced with exactly the same question. And you are of the view that, yes, you can get both of these remedies.
I'm of the view, in the context of this very unusual case, which was decided under the earlier lis pendens statute, that Judge Ball's action in giving Perroncello a second chance to buy the property and in allowing Donahue relief from the financial stranglehold that he was facing and preserving the rights of both parties to seek money damages against one another is not an inconsistent remedy here, particularly
there would be
where
nothing inconsistent here if you had sought additional delay damages. You had a delay of June, July, August, and part of September, apparently some carrying costs, some perhaps significant payments that had to be made. Those surely could have been requested, but those are easily calculable. They are contemplated by the contract itself, that it's going to be covered by the actual delay costs, not by the liquidated damages clause. And that seems to me to have been what was left open, was that kind of financial remedy. And for whatever reason, your client chose to try to get the liquidated damages instead of coming forward with the actual delay damages.
the parties agreed when they signed the contract, Justice Sussman, that the only damages would be liquidated damages. Donahue's action in pursuing liquidated damages is absolutely true to the contract. I think this Court should also realize that at the time, and I'd ask the Court again to take another look at what Judge Ball did in 1999 when she learned that there may be this misinterpretation of her intentions. But at the time of the entry of the specific performance order, there was no matching order on the part of Judge Ball on the liquidated damages claim. Judge Ball clearly understood that she was preserving Donahue's rights to seek his money damages.
No, I understand that, and that's the question I asked you originally. Let's assume she had gone right on and said, and I find this a breach, and I award liquidated damages.
I don't see a difference, Justice Marshall, in whether she had taken that action at that point.
I agree with you. There is no difference.
Yeah.
And if that had been appealed, you would be in the same position, that you would have had an order of liquidated damages and specific performance.
But she corrected any mistake about the specific performance language in her order of September 4th, 1998, when she revisited the situation in August of 1999. And when a judge makes plain, as she did here, that all rights to seek damages are preserved, and Donahue was seeking liquidated damages, I repeat myself, and I don't mean to use the word punish, but I don't think Donahue should be punished for proceeding in accordance with that order, and I think the order of the court trying to do justice should be venerated. Thank you very much.
Thank you, Mr. Farrar.